On a crisp December morning, Washington, D.C. buzzed with anticipation. The city's heartbeat seemed to quicken as crowds gathered, their breath visible in the cold air, waiting for a decision that would echo far beyond the marble steps of the Supreme Court. Inside the hallowed halls of the Supreme Court, all 9 justices took their seats, prepared to deliver a verdict that would reshape the boundaries of American privacy. The atmosphere was tense, every eye fixed on the bench, knowing history was about to be made. In an era marked by deep political and social divisions, the justices spoke with one voice. Their unanimous decision sent a powerful message. When it comes to fundamental rights, unity is possible. Together, they rewrote the rules for digital privacy, setting a new standard for the nation. The case at the center of it all, Miller vs. United States, would forever alter the way our online lives intersect with the sanctity of our homes. It was a case born from the digital age, where the lines between public and private had grown increasingly blurred. The ruling was clear and unequivocal. Your digital searches alone cannot justify a search of your home. No longer could the government use your online queries as a backdoor to invade your most private spaces. This was more than a legal technicality. It was a bold, resounding stand for the Fourth Amendment in the digital age. The justices reaffirmed that constitutional protections must evolve alongside technology, ensuring that our rights are not left behind as the world changes. For years, technology had raced ahead of the law, leaving our digital footprints exposed and vulnerable. Every search, every click, every question we typed into a search bar could be tracked, stored, and scrutinized, often without our knowledge or consent. The government argued that online queries were fair game, claiming that what we searched for online was no different from what we did in public. But the court drew a firm line, recognizing that the digital world is not a free-for-all for law enforcement. The sanctity of the home, they said, is absolute. No matter how advanced technology becomes, the home remains a place of refuge, protected from unwarranted intrusion. Legal experts were stunned by the sweeping nature of the decision. Civil liberties advocates, often divided on strategy, stood united in celebration. For once, the message was clear and the victory decisive. The headline was seismic: Supreme Court backs privacy in 9-0 stunner. News outlets across the country scrambled to cover the story, recognizing its significance for every American. This decision touched every American with an internet connection, from students researching late at night, to parents seeking medical advice, to anyone who ever wondered if their private searches could be used against them. This ruling offered new peace of mind. It protected anyone who'd ever searched for something personal, controversial, or simply private. No longer would a moment of curiosity or concern online be a reason for authorities to cross the threshold of your home. The court's message was clear: our homes remain our castles, and our search history's not the key. The digital age may have changed how we live, but it has not changed our fundamental rights. In the ongoing quest for security, the court decided that liberty must not be sacrificed. On that December day, the Supreme Court spoke as one, and in doing so, it reminded the nation that privacy, even in a digital world, is a right worth defending. David Miller, a quiet Ohio librarian, lived a life that many would call ordinary. His days were filled with the gentle rituals of reading in his favorite armchair, tending to his backyard garden as the sun rose, and spending quiet evenings researching his latest historical interests online. He was a man of simple pleasures, content with the world of books and the peace of his own company. One of David's passions was colonial history, especially the evolution of muskets and early firearms. His curiosity led him to browse antique firearm forums, read scholarly articles, and collect digital images of rare muskets. To him, it was a harmless hobby, a way to connect with the past and satisfy his inquisitive mind. But in the digital age, even innocent curiosity can leave a trail. Then, one morning before sunrise, David's world changed forever. Federal agents, armed with a warrant, arrived at his door. The quiet of his home was shattered by the knock that would alter the course of his life. Their only evidence? A list of his online search history, pages he'd visited, questions he'd typed, and images he'd saved. It was nothing more than a digital footprint, but it was enough to raise suspicion. The agents combed through his home, searching for anything illegal. All they found were shelves lined with history books, stacks of old magazines, and a single family hunting rifle locked away in a safe. There was no contraband, no secret arsenal, just the artifacts of a curious mind. Despite this, David was handcuffed in his own living room, his personal belongings bagged and tagged as evidence. His life was upended, his reputation suddenly in question, all because a government algorithm had flagged his search terms as suspicious. News of his arrest spread quickly, igniting a national debate. Reporters crowded outside the courthouse. Headlines blared about a controversial arrest, and the public demanded answers. David's legal team argued passionately that his Fourth Amendment rights had been violated. They insisted that a person's online curiosity, no matter how unusual, should never be grounds for a home invasion or an arrest. In court, his lawyers made the case that browsing history is a reflection of thought, not intent. They asked, should the government have the power to treat digital curiosity as probable cause? The government, however, argued that in a world of increasing threats, digital patterns could signal criminal intent. They claimed that algorithms were necessary to keep the public safe, even if it meant scrutinizing private searches. Lower courts were divided, unable to agree on where to draw the line. The case quickly escalated, reaching the highest court in the land, the Supreme Court. David Miller's ordeal became a symbol, sparking protests and heated debates. He was no longer just a librarian from Ohio. He was the face of a national reckoning over privacy, technology, and the limits of government power. Across the country, people watched the news with bated breath. Families gathered around their televisions, friends debated in coffee shops, and strangers wondered, are our online searches truly private, or are they potential evidence against us? The answer to that question would define the boundaries of privacy for an entire generation, shaping how we live, learn, and explore in the digital world. David's story was no longer just his own. It had become America's story, a reflection of our collective anxieties and hopes about freedom in the information age. The outcome of his case would ripple outward, affecting every citizen with a search bar, every student with a question, every parent with a concern. As the Supreme Court prepared to decide, the stakes had never been higher for David, for privacy, and for the future of digital freedom in America. The Supreme Court's decision in Miller v. United States was revolutionary. The justices established the digital wall. Online activity alone can't justify a home search. The Fourth Amendment, they ruled, must evolve for the digital era. Our digital lives are extensions of our minds. Curiosity, not criminality. The court warned that using search history as probable cause would chill free inquiry. Now, police need more than just digital evidence. They need real-world proof. This landmark protection means Americans can research, question, and learn without fear. The decision draws a bright line. Your home is your sanctuary, and your online searches are not a warrant. The digital wall is a shield for ordinary people in an extraordinary age. Our data may be out there, but our homes remain our castles. The Miller case forged an unlikely alliance, the ACLU and the NRA. Both saw the government's actions as a threat to core rights, privacy, and the Second Amendment. The ACLU argued for free inquiry. The NRA warned of a chilling effect on gun owners. Their joint legal brief was a powerful statement. The Fourth Amendment protects all other rights. Whether researching protests or firearms, seeking information is not a crime. This partnership sent a message: privacy is not partisan. It's American. On the Supreme Court steps, their unity was a striking symbol. The fight for David Miller was a fight for everyone's liberty. Even the fiercest adversaries can unite to defend the Constitution. When fundamental rights are threatened, common ground is possible. The Supreme Court's unanimous decision was a forceful defense of privacy. The justices drew a direct line from colonial abuses to modern digital dragnets. They declared, the home's privacy is sacred, and online searches are thoughts, not actions. To treat curiosity as evidence is to punish thought itself. The opinion's language was clear. The Fourth Amendment shields us from government intrusion, not just neighborly judgment. The decision's unity sent a message. Privacy is a core constitutional value, not a political issue. The court balanced security and liberty, requiring real evidence before a home can be searched. National security concerns were acknowledged, but not at the expense of freedom. The ruling demands real police work, not shortcuts through search history. The home remains a refuge, and digital curiosity is not a crime. The founders' principles endure, even in a world they never imagined. The Miller ruling changed the game for law enforcement, citizens, and tech companies. Police can no longer use digital surveillance as a shortcut. They need real evidence. For Americans, it's a victory. Your curiosity is protected, your home is safe from algorithmic suspicion. The internet can again be a place for learning and exploration, not fear. Tech companies now have a stronger legal basis to resist broad government data requests. They can push for more privacy, transparency, and encryption. The decision will inspire new laws and a public debate about digital surveillance. It ensures constitutional rights keep pace with technology. The Miller case didn't end the privacy debate, but it reset the terms. Government power is checked, citizens are empowered, the impact will last for generations. The Supreme Court's decision echoed far beyond US borders. Privacy advocates worldwide hailed it as a victory for digital freedom. The ruling sets a new global standard. Digital curiosity is not probable cause. Countries in the Five Eyes Alliance must now reconsider their surveillance laws. The US decision offers a powerful argument for stronger privacy protections everywhere. Tech companies can use Miller as leverage to resist weaker standards abroad. The ruling may spark a global rise in privacy protections. In an era of rising authoritarianism, the US stands for both security and freedom. The decision is a symbol. A free society protects private thoughts from state power. Miller v. United States is a call for a more private, more free digital future. The world is watching and responding. The Miller decision puts the US at the forefront of digital privacy. While Europe's GDPR focuses on corporate data, Miller targets government overreach. The UK's broad surveillance powers now stand in contrast to America's new limits. Canada and Australia face renewed pressure to protect privacy. Miller offers a model constitutional rights as the foundation for digital privacy. Unlike statutory rules, this is a fundamental right, harder to undo. The US approach ties digital privacy to the sanctity of the home. It's a powerful alternative to regulatory models abroad. America is once again a leader in the global privacy conversation. The world's democracies are taking note. Liberty, not just data, is at stake. Miller v. United States is a landmark, but not the end of the fight. It's a crucial chapter in a much longer story. A story that continues to unfold every day in courtrooms, legislatures, and even in our own homes. Our rights must be defended, not just declared. It's not enough to have them written on paper. We must actively protect them, challenge those who would erode them, and ensure they remain meaningful in our rapidly changing world. Technology evolves at a breathtaking pace, and, with every innovation, new threats to liberty will emerge. The tools we use to connect, create, and communicate can also be used to monitor, control, and restrict us. Today, it's search history. Tomorrow, it could be facial recognition, predictive policing, or even artificial intelligence making decisions about our lives. The landscape of digital rights is always shifting, and we must keep up. The responsibility is ours. Stay informed, demand accountability, and support those who defend our rights. Every voice matters, whether you're marching in the streets, writing to your representatives, or simply having conversations with friends and family. The alliance that won Miller shows liberty transcends politics. When we come together, regardless of our differences, we can protect the freedoms that define us as a society. David Miller's ordeal is a warning. Threats to freedom often come from good intentions. Even well-meaning laws and policies can have unintended consequences that chip away at our rights. We must balance security and liberty, question new tools, and demand transparency. It's our duty to ask hard questions and refuse to accept easy answers when our freedoms are at stake. Celebrate this victory but remain vigilant. Every win is a step forward, but the journey is far from over. Teach the next generation about their rights. Pass on the knowledge that possum, the knowledge of mon tendor, the saben person, passion, and the courage to stand up for what's right, so they too can defend their freedoms. Demand privacy by design from tech companies and respect from government. Insist that our digital world is built with our rights at its core, not as an afterthought. The Supreme Court gave us a shield. It's up to us to hold it high. Laws can protect us, but only if we use them, cherish them, and refuse to let them be weakened. The future of digital freedom depends on all of us. What will you do to protect it? The next chapter is being written right now, and your actions matter more than ever.